Hi, everyone. Sarah and I love doing the Off the Clock podcast, and we would love to make sure we're answering the questions that you have. So if you have questions for a Q&A episode or ideas for future episodes, please email Sarah or I. Last name, first initial at millerjohnson.com. Obviously, you can find us on the firm's website as well.
Welcome to Off the Clock, the webcast of employment attorneys at Miller Johnson, where we discuss what is happening in the HR world and provide practical insight and advice. We are your co-hosts, Rebecca Strauss and Sarah Willey, two employment lawyers who spend their days guiding employers through all of the challenges that workplaces offer.
Hi, Sarah. How are you?
Great, Rebecca. How are you doing today?
I'm good.
It's so good to see you.
You too. We are available on audio podcasts, right, Sarah, for those who don't want to see us, but want to listen while they're driving to work, for instance, or going for a walk or at the gym, whatever. Sometimes it's a lot more convenient just to listen.
Yes.
And to watch.
Yes. And I've, those who are listening regularly and have heard us say that before, they might be tired of hearing us say that, but I've just this week mentioned that a few times to people who are surprised to hear that. So we're just going to keep saying it until I don't surprise people when I tell them that. And I feel like everybody knows that we're also available on a podcast, because I do think that's a great way to be able to access information like this in our busy lives. I am a big fan of podcasts.
I am as well. Car time has become much more enjoyable, right?
Yes. Yep, for sure. So, Rebecca, I know what I really want to talk about this week, because I definitely have a theme and recurring questions. And it relates to this executive order that was issued by President Biden. Yes. And I know the executive order actually has a lot in it. But the clients I'm hearing from are focusing on this non-compete part of the executive order. What do you know about that?
Yes, well, I've been hearing a lot about it too. As you mentioned, the executive order has a lot to do with competition, right? Removing barriers to competition. One element of that President Biden, frankly, had been talking about ever since the campaign was eliminating or restricting non-compete agreements. And so sure enough, in the executive order, one of the parts of it encourages, that's a quote, by the way. We can talk about what that means.
That from a lawyer's standpoint, the word encourage is important, right? Yes.
Yeah, so put a flag on that. We'll come back to that. President Biden has encouraged the Federal Trade Commission, the FTC, to initiate its rulemaking process to limit unfair non-compete agreements. It's a little wordier than that. I'm going to have to read it because I don't have it memorized. Is encourage the FTC to employ its statutory rulemaking authority to curtail the unfair use of non-compete clauses and other clauses in agreements that may unfairly limit worker mobility.
Okay, so
that's a mouthful.
In common English, President Biden has asked the FTC to make a rule, right?
Yeah. Well, he has encouraged them.
Asked, right? Encouraged. I suppose encourage is one step past asked.
We write policies for a living. So that's why we're stuck on that word. Right, exactly. We encourage you to come to work on time.
That's different than saying you have to, right?
Right.
Yes. So
but practically speaking, when the president encourages one of his executive offices, right, one of the administrative offices, which he is ultimately in charge of, to do something, they're probably going to do it. Yes?
You would think. Yes. So to issue a rule to limit or really outright prohibit non-compete agreements that are unfair.
Yes.
Okay.
Yes.
So I have a lot of questions about that. Let's start with this one.
Okay.
Okay. Actually, do you know what I think we should do first?
What?
I think we should explain what we mean by a non-compete agreement.
Oh my gosh, that's a great idea. Because that's exactly what I do whenever a client calls me about a non-compete. Right. Because what we commonly refer to as non-competes, to me, are actually for potentially different types of agreements, although we often include them all in one.
Exactly.
Right?
Exactly.
But you don't have to. So I'll say what I think of when I hear non-compete, and then let me know if that jives with your understanding. So my understanding of a non-compete is it can actually have 4 components, or only 1 or 2 or 3 of these. One is you can't work for a competitor in the same industry, and we'll get into the nitty-gritty on that a little bit. Mm-hmm. One is you can't solicit our clients. You can include potential clients in that. Mm-hmm. One is you can't solicit our employees to leave. In other words, if you leave, you can't take the whole group with you. And then the other component often has to do with confidential information.
Of information, sure.
Right.
So I agree with all of that, although I guess the semantics I use are a little different. I use the term non-compete to only mean the first thing that you're talking about, prohibiting an employee from working somewhere else. And then I use the term non-solicitation to refer to the second and third things you talked about. And then I use the term confidentiality to refer to the fourth thing. And I think when we think about this executive order that was issued, President Biden was using the term non-compete in that way. In other words, he's encouraging the FTC to issue a rule relating to agreements that prevent employees from working somewhere else. Do you agree with that?
I absolutely
agree. Okay, so to be clear,
that.
Right, when we're using that term non-compete as it relates to the executive order, that's what we're talking about.
Yes, absolutely. Even though what clients often title non-compete agreements includes
more than factors. That. But it's really what President Biden is worried about is that prohibition on people being able to leave a job, look somewhere else, and go work for a different company.
And to put you're absolutely correct. And what I'm about to say is not in the executive order at all. But to put a finer point on what he is actually interested in, there's been comments that talk about lower wage employees, mm-hmm. right? And when in the executive order, he talks about unfair. He doesn't say all non-competes. He says unfair non-competes. Yeah. And there's been stories in the news about Jimmy John's, for instance, right, where folks making the sandwiches are subject to non-competes, other lower wage workers. And do we think that is probably what motivated President Biden to issue this executive order?
Probably, right. Okay. All right. So my first question that I'd love to talk to you about is, can the FTC do that?
Well, that's a good question.
Because it's a contract, right? So we commonly understand a non-compete to be a private contract between an organization and an individual, right? So are we saying that the federal government now can step in and start telling private entities that they are not allowed to enter into certain agreements?
I think that is the position the executive branch is taking, for sure. Will that be litigated? Yes.
For sure.
Is it obvious the FTC can do this? No, it's not obvious. They're going to make the best argument they can, right? And then most likely it will be litigated.
Okay.
Yes.
And so the FTC's authority is centered around, well, they've got lots of authority, but in this area, really, their authority to issue a rule like this would be to enforce our federal antitrust laws,
yes,
right?
Absolutely.
Right.
Yep.
So they would have to. So I imagine when they issue the rules, they will say, "We are doing this in order to enforce our antitrust laws."
Yes, absolutely.
And I would have to assume that lawyers are going to be involved and they're going to anticipate potential legal challenges, and there's going to be some strategy there when they draft the rules, hopefully, to put the FTC in the best position possible for the rules to be enforceable and to not be overturned by a court, right? Which means we're probably not going to see I don't think we're going to see an overbroad rule that says nobody can ever enter into a non-compete, because that is highly likely to get overturned.
I completely agree with you. I have no inside information on this, but I assume there is a team of lawyers in Washington, D.C.
who are on top of
employed by the U.S. government,
yes,
working on the ins and outs of it and making sure it is tailored to meet that need. The President Biden's statement about the executive order, which we mentioned includes lots of other factors as well, lots of other potential rules, is all centered around competition and activity that the administration feels is anti-competitive. And it applies not just to the labor market, but other issues as well. But as applied to the labor market, he has framed the labor market like any other market, right? Like the cell phone market, like cable, like internet, etc.
Right. Interesting.
And has framed this issue as a restriction on free competition in the labor market.
That's really
so when you think about it like that, the FTC is certainly involved in private parties that try to contract to do something. There are companies that try to merge, for instance, right? Okay. And the FTC may say, no, you can't do that because that will unfairly restrict competition in the workplace. He mentioned how these types of agreements drive down wages, for instance, right? Because
because it drives down the competition.
No one is allowed to change their jobs. Employers don't have the motivation, right? The free market motivation to remain competitive with wages. So it will certainly be framed that he will frame the labor market like any other market, right? And use the FTC's authority. But
got it.
And that remains an open question to your point. I mean, it is going to be litigated.
For sure.
And
yes,
we'll see.
And
what
we
happens.
don't, right. So I feel like we could say with some confidence now that likely the FTC is going to, the rules that actually come out of this, when they come out, we'll talk about that when, are going to be tailored in some way.
Yes.
And the FTC's lawyers are probably right now, working on trying to figure out the best way to craft those.
Absolutely.
And we've got some guesses as to how they might be tailored, right?
Yep.
But this idea, I am getting a fair amount of calls with this idea of questions about, can we even have non-competes anymore, right? And I think it's unlikely that the FTC will outright ban them, but they are likely to require them to be pretty narrowly tailored.
I agree. I think it's possible they might try to go that far. I think they're feeling pressure, maybe from some constituencies, to do that. As we know, there are some states that outright ban them, right? So that is not a crazy concept.
Right.
For those of us in states that allow them, it might seem unusual because they're so prevalent in some areas, right? But some
Good point.
So it is a concept that's already out there.
Good point.
In states like California, right, which California tends to kind of be on the front end of these things a lot, and almost like a laboratory, right, for new types of employment laws, and then sometimes the feds pick up on it.
Right.
So
that is very much an emerging issue in state law, too. Yes. And I think it's important to talk about that. So when we think about this idea that the FTC is going to do something with regard to non-competes, I do also think it's important for employers and businesses to remember the enforceability of non-competes is not a new concern, right?
No. Isn't that the first question? Setting aside the executive order, we've been having some before this executive order. That was when someone called about a non-compete, whether it was someone who had a former employer threaten to enforce it, whether it was a client who wanted us to think about drafting. That is the question that is always the first question. Are these enforceable?
Are these even enforceable anyway?
Absolutely. That's question number one, constantly.
Okay.
Yeah.
And I heard you say something really interesting a minute ago, and that is states have laws about that. When I first started dealing with non-competes, it really was an issue of whether, honestly, a judge would enforce it. Right. And that was the only thing you really had to think about. And quite often, we would get to know how local judges viewed non-competes and the likelihood that that judge might enforce it and how to best draft it, et cetera. But already we have a new layer right, of legal analysis to consider, and that is also state legislatures have passed laws restricting or limiting or outright banning non-competes. Is that right?
That is absolutely right. And that's been a hot issue lately. I think in the past 4 years, 16 states have passed new laws restricting non-competes in their state. Not necessarily banning them outright, but putting restrictions maybe on timing, on geography, on what types of employees can be restricted by them, et cetera, et cetera. So it's, for those of us that have been following this, it's not a shock that President Biden would take this up, right? This is not an issue, right, that we haven't heard debated in the last few years.
And I know in California there is an outright ban on non-compete. So for any of our listeners who have employees in California, important PSA, right? They are not allowed under California law, and actually, interesting, under California law, it's illegal to even have them in the agreement, right? So not only are they not enforceable, but it's a violation of California law to even try to get an employee to sign an agreement with a non-compete.
So let's pause right there for a moment. And I know we've talked about remote workers on almost every podcast because we started this
we just can't
during
help
COVID,
it.
right? And that is what the
it
year
is
and a
just
half
what
has
we're
been
talking about, right?
From an employment perspective. So let's play that out a little bit. So an employer that's located in Michigan or another state where non-competes are generally acceptable with certain guide rails around them. And maybe they've heard us say or read somewhere that they're not enforceable in every state, but the decision has been made, we're just going to put it in our handbook, or we'll have every employee sign it on the way in, and we'll worry about enforcement later, right?
Which is often the case.
We're just going to have this blanket policy, and when it, hopefully it won't become an issue, but if it does, right, that's when we'll call the lawyer and see what our options are. But what you're saying is, if you have an employee in California, you don't have to have a facility in California. You could have someone working remotely.
Yes, I'm following you. Yes.
In California.
Some of our listeners are following along going, yes, I do.
I know. That pause was intentional. It's a dramatic pause. If anyone has someone working in California, just having the employee sign the agreement is an unlawful act.
Correct.
Okay. So I don't want to spend the rest of the hour talking about remote employees and what it means to have employees in lots of different states. This is just one more example, though.
Yeah, and
of
they
how
really
it's changing the landscape for
and
HR.
I would add too, this is very much an emerging issue, right? So you just said there's 16 states that have laws that speak to non-competes. There are other states in which that's being taken up right now too, right? So for employers that have a practice of requiring employees to sign non-competes, and particularly employers who traditionally have been following Michigan law and have been used to Michigan law and now have employees working elsewhere, I really would encourage them to sort of take a time out and think about where the states in which employees are signing non-competes and making sure that, number one, they're not violating state law simply by having employees sign them, but also there may need to be minor changes to those agreements themselves in order to give that employer the ability to enforce the non-compete down the road, right? Don't have it be a 3-year non-compete. If the state law says it's only allowed to be 1 year, the entire agreement might be struck down on that basis, whereas you could have revised it at the front end so that it complied with the state law.
We could talk about how to actually draft the things and get into kind of take a road down to Nerdville for the rest of the hour. But I think just to wrap up that point, if you have employees in more than one state, again, even folks who are working remote, just working remotely, right? So you don't think you have a facility in another state. But if you have employees sitting in other states, you need to work carefully with legal counsel in drafting these non-competes to make sure that you are covered, or at least know if you're not.
Yeah, fair point.
Right?
Fair point. Yep.
Yeah. We can't possibly anticipate every situation here, but don't assume.
Right.
That you can just write one for everyone.
So the other question I'm getting then from clients who are calling about this is something along the lines of, okay, assuming I'm compliant with the states in which I have folks signing this thing, right? Knowing that this executive order has been issued and the FTC is likely to do something.
Right.
Should I be making changes to my non-compete now? Are there things that I should assume or anticipate are coming from the FTC to better position the organization so that when those rules come out a year from now, I don't have agreements that have been signed in the last year that are completely unenforceable?
Right. So employers obviously don't have to because there is no rule yet, right? So this is not house on fire situation. You better go redraft all your non-competes today.
Right.
When that happens, we will tell everyone, right, Sarah?
Correct.
Yes.
Correct.
And we may have to hire a few more folks to start rewriting everyone's non-compete. So we'll be on top of it, and folks will know that for sure. So you don't have to do anything now. But to the extent that you're drafting a non-compete anyway, and I've gotten this call.
Or people are signing it now,
Yeah,
right?
exactly. Right, we're hiring on an executive vice president for sales, right, next week. We're taking out our non-compete to have her sign. Is this a good time, right, to
think about
think about these things? So we may not see eye to eye on this. So let's just talk it through because there's more than one way to think about this.
Sure.
I would say this is a good time, if you want to think about making it as narrow as you can to accomplish your goals. So don't give up what your legitimate business interests are, right? And I'm not suggesting anyone has to give that up unless or until the FTC says you have to and they lose in court or they win in court, right? Then. But until then, think about what you're really trying to protect and protect that. And now we come full circle to where we started with these 4 parts of traditional non-compete agreements.
Right.
Do you really need the non-compete part?
You mean the ban on somebody working somewhere else?
Or can you protect your business interests with the 2 non-solicitation parts and the confidentiality of information part, right? Might that meet your goals? Because those are the kind of pressures I think the FTC is going to be putting on organizations. Right?
I think that's right. And it's so interesting you say that because I've actually already seen many businesses go down that path, not because of the FTC order or anticipation of it, but because of either a state law, right, like California, or because they've had difficulty getting a judge to enforce a non-compete, right? So they've had to regroup, take a step back, think about how their non-compete is written, and have decided we are going, instead of an outright ban on an employee working somewhere else after they leave, we instead are going to focus on prohibitions on their ability to solicit our customers, our employees, and we are going to really be on top of our confidential business information and business secrets, and we are going to make sure that they can't take any of that with them.
Yes. And those parts of these agreements are not seen as unfair to employees. I'm not suggesting non-competes are unfair either, but some judges see it that way, right? And some legislatures and
see non-competes as unfair.
Yes, perhaps the Biden administration now. But the non-solicitation, the protection of confidential business documents, there's not a lot of push there.
That's uncontroversial.
Against those.
Sure.
Yeah.
Right. And I would agree with that. I've seen courts really across the board enforcing confidentiality and non-solicitation provisions. I'm not aware of a state law that bans confidentiality agreements or agreements against solicitation. And I think it unlikely that the FTC will issue a rule saying employers aren't allowed to do that, right? So to your point, maybe it's an opportunity for employers to be thinking longer term, right, about what they're trying to accomplish, and maybe that's an option for them. As I think about it, one thing we're also hearing a lot of is the job market, right?
That is all, really, we say there's always a question of the week. That is always the question every week for us
that's
lately.
the question of the last 6 months.
Right.
And so I'm wondering, right, we've got two things going on at the same time, which is this discussion of non-competes, but also at the same time, employees have a whole lot of leverage right now when you hire them. And so I'm wondering if those two things together are going to create a situation in which businesses might be less inclined to require a non-compete agreement and instead focus on non-solicitation and confidentiality provisions.
I agree completely. Now I'm going to do a classic lawyer move.
Oh boy.
This is the reason people hate lawyers. So on the one hand, now I'm going to do on the other hand.
Okay.
Right? Don't people
what do you
hate
got on the other hand?
Talk
Yes,
about that?
right.
Well, on the other hand,
Sure.
What do you mean? What is your advice? We're not giving legal advice on the podcast. We're just talking about stuff. So I can do this. I can't do this with clients. So on the other hand, non-competes do have a value to businesses who really are trying just to protect their customer base, their employees, and their confidential information. Because a non-compete can be like a fence around those really critical business interests. And sometimes after an employee leaves, it's harder to tell. It's harder to know whether they're whether they're talking to their new boss and sharing confidential business information, for instance.
Excellent.
Whether they're reaching out to a customer and the customer never tells you that person reached out to them, how would you know?
Right.
So you have the non-compete because it's a lot easier to know when someone's just working, you see their LinkedIn thing or what have you. And then if you can just stop them from working for a competitor, you don't have to worry about them sharing your confidential information.
Or proving that they did.
Yes.
Because where do you get the proof?
They're hard to be notified of. They're hard to prove.
Yeah.
It's a lot easier to prove either they were on the payroll or they weren't, right? And so that is one reason that it should still be part of the conversation. I think for all the reasons we talked about, this is going to be an individual business decision, right? There's no right or wrong at this point, so long as it's legal in the state, right? And the FTC hasn't banned them yet. But that could be part of the conversation, right? About why
that's
you might
a
want
really
to still
valid point. And if I'm reading the tea leaves correctly, which I often do not, so audience know that, right? I'm thinking to the extent the FTC doesn't outright ban non-competes, but instead limits their use, right? We're going to be, I'm sort of looking at it through the lens of having to enforce a non-compete with a judge that doesn't like them, that we know doesn't like them, right? That's the standard I'm thinking about, okay? Yep. And so I would anticipate that for businesses that have certain employees, okay, that have access to legitimate competitive information, right? The most common example we think of are high-level sales employees, R&D, research and development.
Those are the classics.
Those are the classics, right? I would guess, if I'm talking to a client about those employees, I would say, I think it likely, if that's a highly paid, high-level position, the FTC is going to continue to allow you to have a non-compete with that employee. But you should take a look at the agreement and make sure, right, that it's narrowly tailored to the extent that it can be, right, in terms of time and geographic location.
Yep.
It talks about why you need to have a non-compete with that person, right?
Yes.
What their job is, what access they have to your customers, et cetera, okay? Just like we always have, quite frankly.
Right.
On the other hand, if we're talking about businesses that are, just as a matter of course, requiring all employees to sign a non-compete because they come in, I do think that business should be assuming that the FTC might require them to change their approach.
Yep.
Right? And the classic example is the Jimmy John's example, right? Who got in trouble recently because apparently they require everybody who makes a sandwich for them to sign a non-compete,
And by the way, can I just comment on that for just a moment?
You can.
Because when you go to Jimmy John's, if you've actually
You can see how they make the sandwich.
The sandwich makers are behind us, the glass.
There's no secret.
Jeez. And when that story broke, we have a Jimmy John's, right, a block away here.
Right.
I went down and I'm watching these folks making sandwiches, thinking about the non-compete story. And I'm like, and
this is the life of a lawyer, by the way. Then you can't even get a sandwich.
I'm sure someone had advised it. I'm sure there is an argument. I would love to know what it is. that process is somehow
maybe it's the bread.
Confidential.
Maybe it's the bread.
The recipe for the bread.
The recipe for the bread, perhaps. The bread is excellent.
Bread is good.
And why and how it smells so good, I don't know. So maybe it's the bread, but I agree with you. I think they lose the argument that those sandwich makers have that they have a legitimate competitive interest in the sandwich makers not working for a competitor because they know how to make the sandwiches.
If I was the plaintiff's lawyer, and I've never been a plaintiff's lawyer, but I would love to, frankly, just on that case,
right?
I would just take a picture of the inside of a Jimmy John's,
blow it up
everyone,
in front of the
all
jury.
These low-wage workers, college students, etc., who work incredibly fast. It's amazing. But anyway, you can see the assembly line. You can see how they're doing it. I would just take a picture and put that on the front page of the brief. And my narrative would be 2 words. Come on.
Yes. Right.
And so that's what I would
so for businesses that have very broad non-competes like that, right? You and I work enough in this field to understand the business reasons behind doing that, right? And likely it's likely been the case all along that it would be very difficult to actually enforce those non-competes. So to your point, and so now on top of it, those businesses might anticipate a federal rule from the FTC saying you're not supposed to have those non-competes. The sandwich makers reading about that even and knowing, right, that this is a bigger issue. So for those types of non-competes, I do think there's an opportunity also to give that some proactive thought, right, as we're waiting for these rules to come down.
Absolutely. All right. Well, anything else you want to talk about with non-competes before we get back to work? We really can talk about non-competes for a very long time.
We really can. We really can. No, we'll just be keeping an eye on it. And as always, right, we will be on top of it and issuing client alerts and other things, talking about it again when we hear more.
Good. Okay. Well, let's get back to work. Back on the clock.
Thanks, Rebecca.
Right.
Have a good day.
Bye, Sarah.
Bye.